This show furnished by Karl Gerber and Employment Lawyer Group.
Talk Radio 790 KABC, another episode of Karl Gerber, Workplace Lawyer.
Earlier this week, I was consulting with my clairvoyant. She told me there was going to be a big change in employment arbitration. The next afternoon, when I was listening to the news on KABC around the start of the swing shift on the ranch, they said the U.S. Supreme Court had a case about employment arbitration. Goodness. You didn't hear about this, did you?
Are you serious?
Are you making fun of me because I'm using a clairvoyant?
No. Do you really think there'd be the latest case coming out by the California or the United States Supreme Court on employment law and I wouldn't have read it?
Does Epic Systems v. Ernst & Young, U.S. Supreme Court case number 16-285, and the companion case at 16-300-307, heard on a writ of certiorari. Certiorari, if you wish, change anything?
No, but why do you have these case numbers in your head? Even before Epic Systems, it was assumed that employees who signed binding arbitration agreements with their employers could not be part of class actions. The issue was whether the right to engage in concerted action like unionizing is ruined by a rule that you're going to go arbitrate. So when we come back, we're going to cover this United States Supreme Court case that made the news this week about employment arbitration on the Karl Gerber Workplace Lawyer Show. I'm a real attorney, Karl Gerber, speaking to Remus Helms, who operates a ranch with cosplay actors.
She will be waiting when my lonely journey is done. Take this job and shove it. I ain't working.
Talk Radio 790 KABC. You're listening to Karl Gerber, Workplace Lawyer, heard on this station. And Sunday nights, 7 to 8 o'clock, we've been talking about an employment law checkup for a business owner. This is Memorial Day weekend. I did want to say that if you are a member of the armed services and you're fired from your job for having to take leave for the military, that can be wrongful termination. And in terms of the cases that I feel employers are the most nasty about and least understanding, it's probably leave for people in the military and religion. With that said, we're going to talk to Remus Helms more, who's sort of a fictional character owning a business, getting an employment law checkup. He raised the issue with me before we broke about a new case called Epic Systems from the United States Supreme Court. He seems to know all the companion case numbers. Kind of weird. And the case has decided that if you sign an arbitration agreement with your employer, which 54% of all employees do in this country, they cannot have a class action. And this also has implications for unions because the thought had been that it was concerted activity that you cannot be blocked, and you can't block a class action on concerted activity. So getting back to this discussion with Remus Helms here, I guess you should continue, Remus.
Well, I always like the idea of having my employees bring a class in action against me.
Why? You want to be sued?
Oh, that's what it means? Just thought it sounded good.
Yeah, class action is when a bunch of employees get together and bring a lawsuit, or one person brings it on behalf of 100,000. So on the last show, you can hear it on YouTube or workplacelawyer.org. I was told that your robot told me humanoid takes care of the human resource issues on your ranch for the non-human, dead, undead, unborn, slave master, and superheroes. Is this guy humanoid trained on human resources?
Hell no.
I have serious concerns about your ability to enforce all the California and federal labor laws if humanoid is not even trained in human relations.
We have arbitration.
You have cosplay actors who are dressed as arbitrators?
No. The Scribblers made some beautiful arbitration agreements for the workers on the ranch.
Can I see your arbitration agreement? Oh, thank you, Remus. This is a really impressive document. Really nice penmanship here, nice calligraphy. And my grandfather was a famous calligrapher, and he used to put little symbols of, like, animals and things in the letters, but the symbols here, I can't say what that symbol is on the air. That's really disgusting. Is that what you claim was infringed?
It's not to scale.
Oh, I wouldn't expect it to be, but notwithstanding that, the scroll is a couple feet long.
Actually, that's the branding we put on the ostriches. It's the trademark of the RAND.
Oh, of course. That makes a lot of sense. Can we talk about the terms of your arbitration agreement? It specifies only a retired Supreme Court justice can arbitrate your employment disputes.
There's something wrong with that.
Well, besides the fact there are not too many retired Supreme Court justices around, the arbitration agreement requires they only wear a Minotaur headpiece when they're arbitrating.
How else is the arbitrator supposed to keep order?
With your employees, you do have a point.
So you agree?
I'm just not sure a retired Supreme Court justice would be interested in wearing a Minotaur headpiece to arbitrate a dispute between cosplay actors.
Now remember, Mr. Gerber, my hairstylist, too, and the driver, and...
Yeah, even a retired Supreme Court justice who might arbitrate with a Minotaur thing, maybe you're going to find one, I don't know, but there's a clause in here that the arbitrator has to be older than you. That is yet another hurdle in finding someone to actually arbitrate your dispute.
I just wanted somebody I'd respect.
I suppose the Minotaur headpiece would add a lot of credibility to the arbitrator.
Well, certainly.
Don't you think that an active sitting judge in a public courtroom who hears cases every day and has a research attorney to figure out the law, or maybe a jury if your peers, well, that might be a problem in your case, don't you think those folks would be better than a retired Supreme Court justice older than you wearing a Minotaur's headpiece during an arbitration?
No, I wouldn't expect the arbitrator to be up to date on the law. That's why the agreement has a choice of law provision. The arbitrator is only supposed to enforce the laws that existed in 1976 when I made the San Fernando Valley my home.
Courts are not supposed to be enforcing absurd terms. There are quite a few in this arbitration agreement you expect your employees to abide by.
I thought every deference would be given to arbitrating.
Audience, there is a way to get rid of employment arbitration. You know, it's the Congress and the Senate. They could outlaw it because it's all based on a 1925 idea about commercial parties arbitrating. Doesn't work very well in employment law to have one person who is usually a certain type of person because they're a retired judge or a lawyer that is done with their career. Lots of men, too, deciding a case.
Mr. Gerber, I heard arbitration might be fun because it's arbitrary, and the arbitrator doesn't have to enforce the law.
You're right. The arbitrator is not bound by the law, and this is real. This is not a joke. I'm not sure it's supposed to be arbitrary, though.
I just sort of like the idea of one really old guy with a Minotaur headpiece making a decision. It might just be wrong because there's no way of appealing the decision. Hell, I could have to pay millions of dollars because the arbitrator got it all wrong. Or maybe his Viagra didn't work the night before. Or he thinks it would be funny to rip me a new one. Or already have it ripped for me.
It's a really bad business decision here to have this arbitration you're considering for your employees.
Should I get the stompers to do their thing on the arbitration parchments?
Forthwith.